I'm David Lombardo, and this is WCNY's The Capitol Press Room, and we're joined in the studio by State Liquor Authority Chair Lily Fan, who's here to discuss the state's blue laws and regulations, including how they've been updated to accommodate some of the partying envisioned for the World Cup celebrations this summer in New York. Welcome back to the show, Chair Fan.
Thank you for having me again, David.
So we're speaking while the World Cup games are being played, and I'm hoping you can talk about what has been done to facilitate the level of imbibing and partying that New Yorkers and visitors to New York may want to engage in during the tournament.
Everybody knows that Governor Hochul and Mayor Mamdani are huge sports fans. The governor have instructed the agency for many, many months to try to look for ways to make things easier for small businesses and provide opportunities for watch parties and for permitting to happen faster and sooner so that licensed premises can serve, in the locations that they would want.
And what does that mean compared to what was available a month ago, for example? Are there certain types of activities that you're envisioning happening, maybe outdoors or at hours that might not have been allowed in the past? What's the landscape going to look like? I mean, how is it going to be different?
So the governor proposed and passed a bill and signed into law a bill that would allow counties that were not 4 a.m. counties to license premises in those counties to serve until 4 a.m. Mm-hmm. There are 8 counties that actually had service hours that end before 1 a.m. and now all of those premises can serve until 4 a.m. Our agency has also made one-day permits more available. Those were available before, but we have created a process that make it easier. There were a sort of a limit to how many they can apply for, and now you just need to fill out one easy application and you can apply for all of the game days that is being played. So, the games have already started from June 11th until July 20, and there are a lot of licensed premises that have already applied, and if you haven't applied, we encourage you to do so. If you want to serve in contiguous spaces outside of your premises, we are also issuing licenses to locations that are isolated watch party locations that are not actually contiguous to a licensed premise. We're also encouraging people to have large-scale watch parties.
And what are you doing to make sure that the businesses who might be interested in doing this are aware that this is an option for them if they are looking to do something licensed, or maybe they didn't even think about it, and now maybe you could let them know that it's something they could do? I mean, are there outreach campaigns?
We've been issuing press releases. The governor is out talking about it. We are very proud of our relationship with our restaurant stakeholder groups, and so we try to promote it through them so that they talk to their membership, and there are thousands of restaurants that hopefully are aware of these opportunities and making use of them.
And for the vast majority of establishments and individuals that do take advantage of this, it's going to be done in a responsible manner. It's going to be fun, but there are probably going to be some bad examples where maybe law enforcement is needed or there are local concerns. And how are communities bracing for that? I mean, are you working with areas to say, hey, just an FYI, this area has this permit, you might want to be aware of that now? What sort of safeguards are put into play?
So we are working very closely with state police, local police, and particularly, of course, NYPD to try to make sure that the process is smooth. If you're applying for a one-day permit, you do need to notify local police department. And if the local police says that they have concerns about certain operators in certain location, we'll certainly take a look at that. I don't believe that those concerns have created situations for denials yet, but we also know that also, if you are not following the rules, you're going outside your method of operation, there's been disturbances, there's violence, then in theory, your future permits could be rescinded. And that's what we're hoping would help people, really stay in compliance and make sure that their patrons are safe and that the service is smooth.
Do you view this expansion as a one-off, or do you hope to maybe learn from this experience and make it available and accessible when there are other large opportunities to celebrate something, and maybe it'll be even a shorter window, like a horse racing event, a football game? I mean, are there more opportunities to do this type of thing moving forward?
Yes, the governor actually put forth this year in her budget a proposal to have early service hours for, related to international sporting events. It's certainly a licensing direction that we would really love to move into because we do a lot of licensing work. We do a lot more permitting work. And so if as the administrator of the agency, can move things that are in the permitting queue into the licensing queue. On the back end, it will save us a lot of administrative work, meaning that people are not applying for one-offs and that they are actually licensed to service as much as they want to and in the method that they want to. So those are redirection and modernization that we continue to think about and propose.
Well, let's stick with licensing, but before we move on, let me reintroduce you for WCNY listeners just joining us. I'm David Lombardo, and this is the Capitol Press Room. Back in May, the Hochul administration announced changes to your licensing application process in order to eliminate restrictions on dancing in bars and restaurants where alcohol is also served. What restrictions have been in place before, and how were they enforced? Because I have definitely cut a rug in establishments where alcohol was served. So I'm curious what was not allowed or maybe not supposed to be allowed, and what do you envision moving forward?
So one way to explain this is that dancing was always a question in our application, whether you intend when you're a restaurant to have patron dancing and employee dancing, and if you are a tavern, nightclub, whether you intend to have patron dancing and employee dancing. What the Hochul administration has announced to do is to remove the dancing-related question or not consider the answer to that particular question in our licensing process. This has been long advocated by the New York City Hospitality Alliance because they have worked really hard to try to get rid of the New York City cabaret laws. And this is sort of a follow-up to that, is to say, to disassociate the licensing stipulations and the act of dancing by the patrons. So this is really only about patron dancing. If employee dancing, it's still of concern. That question is not removed. Obviously in dancing, there's establishments that do adult entertainment that have, employee dancing, and that we're still concerned about. But as far as patron dancing, we are basically saying it's okay for everybody to be dancing in restaurants and in taverns, and that we're not going to make that as one of the stipulations in our method of operation agreements.
And so just to be clear, though, if I was on Caroline Street in Saratoga Springs back in the day and the right Bruce Springsteen song came on and I decided to show what I could do to Glory Days or Born to Run, was I not supposed to be dancing? Or were those bars that might have applied for a license where they said, yep, we're going to have Dave Lombardo and people of his ilk doing some sort of lame dancing and thus it's okay? Or was I a scofflaw in that way and many other ways?
I would say for the majority of establishment, no dancing is actually not one of the stipulations.
Okay.
And it's a disclosure issue, whether they told us when they applied that they plan to have patron dancing. That's really what the issue is. And in some, oversaturated areas, in some areas where community voices are very active and loud about disturbances and residents are very close to businesses, in those particular areas, sometimes the fact of the patron dancing has become a cause of conflict, and that the community board or the community groups or block association would say they didn't disclose that they plan to have dancing. And so it's more, sometimes people, in order to be licensed, would stipulate to having no dancing. And this movement will hopefully create a situation where people will not need to make that compromise when they're applying for their license, so that they can have more freedom to do things the way they do it.
here in the state capital, there have been controversies around the cabaret laws in Albany, and that has stemmed from, I guess, what we might think of as more local permitting. Is there still the potential for that additional layer of permitting that might be a burden or another obstacle for local businesses to overcome?
Yes, this just is about what the state liquor authority is considering and looking at in our application process. This does not get rid of any local requirements to get cabaret licenses or any kind of municipality approvals to do dancing. So this is unrelated to that.
And in terms of the authority that you guys have to change this process, in terms of basically ignoring that question, is that something that is done solely regulatorily, or does there some sort of statutory authority that lets you change how you approach this type of question?
We did it through an advisory, and over the past few years, our agency have started looking at a lot of different ways that we can do without having to pass bills and trying to make things easier for businesses. I think this is part of New York Express that the governor has announced as a priority to remove red tape, and this is an element of that.
And is this then in lieu of the so-called dine and dance licenses that were initially part of the governor's budget proposal, then ultimately dropped during negotiations?
This is not necessarily lieu of. This is actually a different thing.
Okay.
The dine and dance license is a way of saying that if there are cabaret places, everybody knows that I came, to this job before I did this. I was working on Broadway, and so I certainly support live entertainment, live musicians, and jobs for musicians and dancers. And so dine and dance, it's sort of more in line with that. Is that if you fully disclose that you plan to have patron and employee dancing, then you can be licensed as such. And that may come up again in the future in the governor budget. We'll see.
And after a quick break, we'll continue our conversation with New York State Liquor Authority Chair Lily Fan. When we get back, we'll talk about restrictions on wholesaler fees that made it into the state budget, as well as efforts to modernize alcohol licenses that did not make it into the final budget, and consider how the State Liquor Authority examines the issue of wine in grocery stores. Support for the Capitol Press Room comes from O'Donnell & Associates, a public affairs firm providing strategic guidance to businesses and nonprofits on navigating policy and regulatory issues. More information is available at o'donnellsolutions.com. I'm David Lombardo, and you're listening to WCNY's The Capitol Press Room, and we're continuing our conversation with New York State Liquor Authority Chair Lily Fan. Under her watch this spring, the state has expanded opportunities for partying connected to the World Cup and has also rolled back some of the red tape related to dancing in New York bars. Sticking with the state budget, you and I talked in February about an effort to restrict delivery fees, storage fees, split case fees, broken box fees charged by alcohol wholesalers to retailers in New York. Can you talk about the language that you were successful in getting in the state budget and what that might mean for the landscape moving forward once you put your rules in place?
So, our agency proposed concepts. The governor's team really did all the work surrounding this, and we're so proud of what they've been able to achieve at the budget table. Senator Skoufis is, the leader on this. He had a bill that proposed for there to be no wholesale fees whatsoever. That was the bill language. The governor's proposal disallowed fees, but for the ones that are permitted by the agency, and that's a version. And then the final language that actually passed suggested that attorneys' fees and brokerage fees are not allowed outright, and that split case fees and any other fees would have to be allowed by the agency by rules and regs in order for it to be charged in the future. In the meantime, is status quo.
And one of us, you, has a law degree from Yale, and that's probably important because the effort to regulate wholesale fees has been caught up in legal fights before this. So what are your expectations for withstanding a legal challenge? Because I imagine wholesalers would like to continue charging whatever fees they can. What are you expecting with a potential legal challenge moving forward with this new statute? And why do you feel good about the ability to withstand a legal challenge?
So
And again, congrats on the Yale Law degree.
Thank you. I would say that we're hoping, and as I said last time, that we hope that this process of setting the rules and regs will be an open conversation, that it would be full of transparency, and that we can sort of get the three tiers together, the manufacturing tier, the wholesale tier, and the retail tier together, and try to figure out what these fees are, how they're being charged, who's charging what. Because we also know that there are wholesalers that don't charge any fees and that all their expenses are reflected in the bottle price. So right now we are in a information collection stage of this. Whether there will be future court challenges, I think that's still down the road. And
But you must feel better about the footing you're on, given the statutory language that you're operating with now.
yes, for sure. I mean, I think, David, you're referring to the split case fee litigation, where the agency tried to set something called split case fees, and they had a formula that that was, fully vetted, and I believe there were real back and forth and conversations to come up with those numbers. And ultimately, the court found that the agency didn't have the authority to set the fees. They didn't really opine on the substance of what was put out as a rule and reg. They said that the agency didn't have the authority under the statute. And so now that has been fixed. So in this budget language, the agency received the authority from the legislature. The governor signed the budget bill into law, and that now we have the authority to go and do this work.
An area where ultimately, when faced with negotiations with the legislature, the governor chose to rescind a policy had to do with some of the broader license modernizations that you and I talked about as well in February. And I'm curious what, if anything, you're going to do in these spaces prior to maybe taking another stab at a statutory update. I mean, are there things that you guys can do in terms of providing flexibility for these different types of operations that you were looking to create sort of specific licenses for, or broader licenses? I mean, is there anything that you are looking to do in those spaces, or is it the status quo until you can take another stab at updating the statute?
I think that we are always thinking about advisory concepts. If it's something simple and we can change our process that is not actually statutorily required, we are always open to those suggestions, and we are in the process of working on a number of advisories, regarding the backlog committee and other things of how we do our work. As far as creating license types, we don't have the authority to do that. And to the extent that concepts have been put out as bill language, I really take that very seriously. And if we've put it in the bucket of this is in the legislature's hand, we really like them to opine on it. And I don't think it would be fair if we put something out as a bill and then turn around and the agency just do it.
Sure. Then you'd be back in court again, too, probably.
Yeah, and there are a lot of things that I don't know that we'll get sued for it, but if it's a bill, obviously someone had made that determination, especially, we have a great relationship with our legislative partners to the extent that some of them have quartered back certain issues and taking it on as a bill. We respect that, and we want to work with them on behalf of the governor to try to get things passed so that, they will get the win and get the credit and be able to say that, I had a part in modernizing alcohol laws. Like any legislator, any staffer who's interested in this area, we really welcome that and want to work with them.
Well, before we move on, let me reintroduce you. For listeners just joining us, I'm David Lombardo, and this is WCNY's The Capitol Press Room, and we're speaking with New York State Liquor Authority Chair Lily Fan. One of the recurring issues here in Albany is this idea of wine in grocery stores, and I'm curious if at all how you guys may have tried to game out what that might look like. And I'm not asking you to opine on whether it's good or bad, but have you guys drawn up sort of scenarios about all these moving parts? Because if you do put wine in grocery stores, it has an impact on liquor stores. So if you give liquor stores something, well, what does that mean for XYZ stakeholders? I mean, do you guys run war games, so to speak, in terms of what it would look like to dramatically change the landscape looks like?
Yes, we have spent a lot of time thinking about that, and I can probably spend 3 hours over dinner to talk about all the facts that come into it. Our team can probably write books about this at this point. There are a lot of different pieces that go into this conversation. Again, each of the pieces have their own individual legislative quarterback.
Sure.
And we are friends and work with all of them and hope that each one of them can ultimately get what they want. And also the pros and the cons, and what ultimately my job is to think about what's good for my licensees and what's good for the state. And so I tend to think about it from that lens, both from a temperance standpoint, the public safety standpoint, and from a abundance standpoint, and also affordability. So I have to figure out a way to balance all of those things, and it's not an easy conversation. And I think we have done enough analysis. We've written so many memos about it, and at this point, I think people of a higher pay grade need to be deciding, the legislature at some point need to be deciding as a group how they want to redefine distribution of alcoholic beverages in this time when people are drinking less. It's important to have non-alcoholic beverages. That's one of the pieces. THC is a new thing. That's, the THC drinks, the hemp drinks, RTDs, ready to drink cocktails, and wine. All of those pieces are going to be sort of discussed together.
Well, we've been speaking with Lily Fan. She is the chair of the New York State Liquor Authority. Lily, thank you so much for joining us in the Capitol. As always, I really appreciate it.
Thank you.
Support for the Capitol Press Room is provided by New York State United Teachers, a statewide union of nearly 700,000 professionals in education and healthcare.